Well, let's resume our activities. Uh, we're going to have a formal closing, like mostly of acknowledgments and greetings. Uh, but this is our closing talk. It is really an honor and a pleasure to have Jennifer Chandler among us. Closing the closing talk is always a kind of a very honorific time slot, I think, because it is the um, kind of the apex of the conference. And Jennifer Chandler does a very interesting work. Um, I think when we think about practical implications of everything that we discussed, somehow, if you are into a democracy, in the debates we are running here, somehow they have to influence our legislation. So it's really important to think of our debates in terms of its legal implications too. So when you have someone that is fully dedicated to this issue of transforming bioethical questions into legal debates, uh, I would say that Jennifer is a reference not just for Canada, but for us internationally. So without further ado, a big round of applause for Jennifer Chandler.
Thank you. Do you hear me? Is this one working? It's not on. Okay. Now is it on?
Yeah.
Oh, yeah. Okay. Well, thank you very, very much for being here. I know it's Friday. I know it's a little bit past 5 p.m. on Friday, so I'm extra grateful to have you here. And furthermore, I'm extra grateful to be here because I heard yesterday that my hometown, Canada, just got 20 centimeters of snow. So can I stay longer is basically what I'd like to ask. And thanks to the organizers for such a really spectacular hosting job. We've had a wonderful week. So thank you all. So yeah, let's launch into it. I would like to talk to you about the topic of the ethics of inferring mental states and functions from brain data. Okay, so let me first motivate this question, but before I do that, I want to mention Kiyoshi Iwazu is a Japanese graphic artist and printmaker whose art I fell across by accident, just sort of looking for brain art, and I there's something about this art that speaks to, I think, the themes in a sort of an indirect kind of way that I'm going to be discussing with you. So a shout out to him for his art throughout. Okay, so let us advance the slide. Okay, so why this question? Why are we worried about the ethics of inferring mental states from brain data? Well, first of all, we have a very long history. We're doing that all the time, looking at people and their demeanor, what they say, their behavior, and we're inferring mental states all the time. Why? Because we're interested in predicting their behavior, their future states. That's very useful information. And also we want to evaluate their current states. We want to know sort of what condition they're in. It might be relevant to us. We might want to evaluate the veracity or likely correctness of what they're saying. There's many reasons why we might be interested in mental states and functions. And so in a way, ethics of doing that, we do that all the time. That's quotidian. How boring, right? But here's what we go into motivating it. There's a growing interest. We look anywhere into the literature, whether it's brain-computer interfaces or which attempt to decode various kinds of things from the brain to affect objects in the world for people who are paralyzed, for example. But there's also interest in trying to find biomarkers for various mental states associated with psychiatric conditions. So the biomarkers for the particular kind of anxious rumination in OCD, or the biomarkers for hallucinations, or any of these things to develop adaptive deep brain stimulation therapies or neuromodulation therapies that will only stimulate when a person's symptomatic. So how to do that? Well, you need some sort of biomarker to know when that mental state is being experienced. So there's all this work being done. And because of this, there's this growing concern about mental privacy. And we had a talk yesterday, I think it was, talking about, it was Renato who was talking about the calls for novel neuro rights. And one of these that's commonly raised is a concern about mental privacy. So we're gathering all this brain data, and the concern is mental privacy. Well, have we moved too quickly? What is the connection between brain data and mental privacy? So there's some ground to investigate there to determine whether there actually is a threat to mental privacy. And this is a very interesting article. Jerry Tang, the first author, Alexander Huth at Austin, doing work on trying to develop, I guess one application of this is a communication neurotechnology. But this is a remarkable paper which made my head explode when I read it last winter, 2023 March. But this was, in one subject, an effort to gather hours of data in the MRI, functional magnetic resonance imaging information, as this person listened to spoken language, and the wash of response of the brain over 40 hours was mapped, and everything was divided up into little time segments and coded according to the semantic meaning to essentially get a map of semantic meaning in this person's brain. That's pretty crazy to me. So if we can do that kind of thing, this is quite clearly at the early stage, right? And there's tons of processing and there's tons of constraining the particular space to make this actually doable through machine learning. But what's really interesting is I'm used to scientists like, Shaw, this is crazy. You ethicists worry too much. The sky is falling. You see horribles under every rock. And you're probably going to try to shut us down. So there's a lot of suspicion, generally speaking, about ethicists and lawyers who are even worse than ethicists. But what's interesting about Tang and colleagues is they have a whole section in their article about mind reading and well, they don't call it mind reading, but they say, we acknowledge a concern about mental privacy. We're going to look at it. And they have a whole section and a series of experiments to explore, okay, what is the real risk of mind reading from this technology we're developing? So I take that to mean that the plausibility of these concerns is clear to the technologists and the scientists as well. And so we have this concern, okay, we're gathering all this data and we're going to start using it for these kinds of really fascinating applications and potentially others. Is mental privacy at risk or not? And if the only way it could be at risk is if there is a chain of inferences from the brain data to mental privacy, point one, or we treat it as if there is. That could also threaten mental privacy. So an invalid inference is equally a risk to people. So valid or invalid inferences might threaten mental privacy. So we have to keep that in mind when the scientific response, well, we can't do this, there's no risk. Well, yes, there is, because we can look at society moving well ahead of the capacities of the technology, and we have to think, okay, what guardrails, what warnings do we do to make sure people don't go a little crazy on this? So mental privacy motivates what I'd like to talk about, or why I ask about the ethics of inferring mental states from brain data. But I also want to hasten to say that privacy is not the only value. We may actually find it valuable at the social and the individual level to give up privacy, to allow the reading of the mind, as it were, in some contexts and to some degrees. So I don't start from the proposition this is actually bad. I start from an agnostic position that we have to understand, what is this chain of inferences? What are the potential consequences of coming to rely on brain data to draw these mental inferences? How is this different from the way we've always done it? Is there anything different? So this is the series of questions I want to explore with you now. And I would like to say that if anyone wants to ask a question or make a comment throughout, I'd be quite happy to stop and engage with those questions as we go along. So we're a small group, so please don't hesitate. So here's a little schematic as I was thinking about, okay, we've got a chain of inferences. The top series of boxes, which I hope you can read, is describing what we do every day. So we have this long tradition of inferring mental states as I've said, normally from observed behavior, demeanor, acts. That's so much part of the psychological wallpaper of existence that we don't notice we do it. More recently, we have come to look for certain kinds of biomarkers, like a polygraph or eye gaze tracking, or detection of other kinds of biomarkers that we think bear on mental states and functions. But notice the structure. We have observed demeanor behavior biomarker to mental state. That's inferential step 1. And then we may care about the mental state. For example, I want to know if someone's in pain who cannot report. I'm just interested in the state. But very often, there will be a second inferential step. We're interested in the mental state not for itself, but for what it tells us about some information of ultimate interest. So if I'm a lawyer and I want to know if someone is lying about some event they saw in the past, my interest is in something to do with the mental state of deception, because I'm interested, I am kind of interested, it's interesting to know they're lying, but I really am interested in whether I believe what they said about the past. So the ultimate information of interest is what's of interest to me. So another example of an ultimate interest is where I'm looking at a present mental state in order to, or functional capacity, to try to predict behavior in the future. So I may be interested, so we do this in law, for example, evaluation of sexual interests in pedophilia of sex offenders to try to make risk predictions about recidivism. So one would look at sexual interests today in order to predict what that person is going to do in the future. So this is sort of a structure of what we do all the time. So now we add in brain data, and we've added a couple of extra steps at the front end. We're observing some brain data. It could be a pattern of blood flow in the neurovascular coupling that's presumed in the bold signal and fMRI. We look at brain, we look at blood flow. Well, actually, we look at ratio of oxygenated and deoxygenated hemoglobin, and we say that's related to blood flow, and then we say that's related to activity, and then we say that's related to some brain function, right? So that's step 1. It could be electrical activity as well, might be step 1. So we get to brain activity, and then we have step 2. We have to figure out how brain activity relates to mental state. And then once we get there, we continue on with the other steps that I described just now. So there's a couple of extra steps in there. So is this importantly different? And if so, how? So these inferential chains, there had a number of years ago, this was a topic of a lot of discussion at the neuroethics interface, the neuroscience ethics interface. And our friend Adina Roskies from this earlier versions of this symposium has an article on inferential distance, she calls it. And this was at a time of a lot of discussion about the risks of mind reading. And people were trying to say, wait a minute, we have a lot of technical problems in going from brain data to mental state. So what are these problems? First, I'm going to get to the ethics in a moment. This is my last non-ethics slide. First question, and here we get into, and this is new to me as a lawyer and a former biochemist, I did some reading and got about this deep in cognitive ontology and discover it's fascinating. I've just added yet an 11th life to the catalog of lives I need to have to do everything that I would like to do. But first of all, if we want to actually do brain data mental state, and we're interested in the mental state, we have to specify a mental state correctly. And this is not easy to do. So in the day-to-day function, we have our sort of rough, intuitive folk psychological senses from introspection and from culture about what minds do. We have to somehow get that specified in some way that it is tractable for scientific exploration. So we have to identify a relevant mental state. Is it the correct thing to be approached at the brain level? Then we have to figure out how to evoke that brain state somehow so we can look at what the brain does when that state exists. That's also another problem, to be sure we're doing that in a reliable way. Then we have the ecological validity problem. Do we really care what the brain mental correspondence in the lab is? Actually, no, we care about, if we're talking about some application outside the world that threatens mental privacy, we care about some application out in the world that has some sort of impact on the person's life. So is that correspondence developed in the lab going to translate to a reliable correspondence out there in the world with that mental state. We haven't even got to the realism or practicality of trying to detect that in a mental state, but we'll set that aside for the moment. Then we have, and this was the topic of an awful lot of discussion, reverse inference problems. So this is, we observe, make a lot of observations of the brain at the time that the state exists, and then we turn around and we want to look at the brain and say that mental state exists. And so this is known as the reverse inference problem. What if a particular pattern of brain activity exists for multiple mental states? Then we don't have that one-to-one correspondence that allows us to be sure that the brain data signifies the mental state of interest. Now, my reading, got quick into statistics, and people here will know better than I at what state we are in dealing with this particular problem, but my understanding is that the amassing of larger and larger data sets and the use of machine learning allows for a more probabilistic assessment of that correspondence, and we are getting a little bit better at dealing with reverse inference in some contexts. And then finally, we have the group to individual problem. We've established this correspondence across a large group of individuals, and we then purport to make some sort of judgment about an individual. So all of these are, I would say, are technical logical, not technological, but technical and logical issues for the inferential chain. But let me just point out, if we go back one slide, these same problems exist in our old way of doing things. It's just a low-tech version. So how do we get correspondence, one, in our day-to-day lives? Well, we get a whole bunch of observations of people, and we, in our minds, come up with some sort of correlation between observed demeanor behavior and mental states. So we already do that, but we do it in a very, in a way that is so built into it, the way we think as social creatures, that we're not aware necessarily that we are building this same kind of inferential process. Furthermore, we are doing group to individual inferences all the time too, which leads to all sorts of problems because we are judging, establishing our information on a restricted set, and someone that is from a different culture, for example, that doesn't behave in a similar way might lead to inferential errors, right? And we see this in courtrooms like the National Judicial Institute in Canada, when instructing juries on assessing credibility, is someone lying or not, has an express warning to the jury: don't rely too much on demeanor. It can be really misleading. We know that we're more likely to believe the beautiful people. We're more likely to believe certain races. We're more likely to be suspicious of cultures that have different sort of customs with respect to direct eye contact. All of these things are known. We have errors of group to individual attribution all the time, and we warn jurors about it. So my point is just that what appears to be so much extra and mysterious here, I think there is a lot of extra and challenging, but a lot of the logic of these steps is shared with what we do anyway. Now, you might say that we have millennia of evolution behind the top approach, and so we probably have gotten reasonably good at it. But notice we've had millennia also of learning to evade others, to deceive. That also is a social function, is a very important one, is to veil one's mental states as well from the gaze of others. So in the social arms war of reading and hiding from the reading of minds, there's time on both sides. Okay, so I get now to where I'd like to spend most of my time today. And these are, this is not a very sort of systematic structure I've given you. This is like a potpourri or buffet approach. They don't have any necessary or sort of association one to the other. They're just 5 interesting topics, I think, when we ask about the questions of the ethics of inferring mental states from brain data. So the first question I want to ask is, okay, what about accuracy? How accurate does all this have to be for us to use it? And is it an absolute measure? Does it have to reach a certain threshold? Or instead, is it a relative measure? We just look at how we're doing this particular social resolving this social question now and ask if using brain data is better. Does it improve it? And if so, then it's good enough to use, even if it only adds a little bit more predictive validity than what we already have, and yet it's not good, it's still good enough. So I want to talk a little bit about that particular trade-off. The second, prediction. What are the risks of extending the inferential chain in time? And here I'm thinking about the potential issues that come up when we purport to identify a person's mental state or trait or capacity or function and use it in the future to make judgments about them. Third, epistemic justice. I think, to me, this is one of the most interesting ones, although perhaps a little bit out there. We'll see what you all think about this. But what I think is really interesting about this move is the potential conflict or divergence between objective and subjective accounts of your own mental state. So imagine you sitting there having a first-person subjective experience, mental experience. I can say, I don't believe you, or I think you're mistaken, or anything like that. That doesn't threaten you directly. You know what you feel. Other people can disbelieve you for their own reasons. But what if you have a particular experience, and then we gather your brain data, and we say, well, actually, your brain data says something else. So we've moved the challenge, or the impeaching party who's challenging you, sort of inside your own head, as it were, right? It's you against you in a particular way, although there's some expert reading and collecting and reading your brain data. But is there some interesting problem that's set up there when we have a situation of conflict over epistemic authority, over your own experience? Do we prefer your subjective self-report, or do we prefer the objective report from you, from your own body? And what happens psychologically when we set that up? Fourth, is there an obligation to read minds? Like, is there far from this reflexive position we take that we must protect people from mind reading? We must stop, collection of brain data. But could we turn that on its head and say, actually, in some circumstances, we have an obligation to read minds? So I will give you a few, through collecting brain data and interpreting it. I'll give you a few examples of where one might make that argument. And then finally, we come back to where we started, mental privacy. First of all, what the heck? Why would we protect? Well, first of all, what is it? Secondly, why would we protect it? And then how much would we protect it? These are all, I think, very important questions as we go forward to try to figure out what to do with these novel neurorights that Renato talked about yesterday, too. Okay, we'll start with number one and work our way through these 5 topics. And you will see, because I'm a law professor, that I use an awful lot of legal examples. I think one could come up with other examples, but I keep trying to draw. I draw from that because that's what I read about and teach, and so that's what's in my head. You'll see also that some of these technologies are existing. They're being used right now, and some of them are speculative. So they don't exist yet. So I'm using them as thought experiments to explore the possibilities, but I'll try to signal when the technology does exist and is being used and when it's not. Okay, accuracy, the threshold. Is it absolute? Is it relative? So, okay, I've asked those questions. Is there a reliability threshold of some kind you have to get beyond? And then secondly, is accuracy the only value? And you can tell I asked those questions. My answer is no to both of them. So we already know, we already draw inferences with unknown error rates. We tolerate that all the time because we have to make decisions. And guess what? There's other values. What about the cost and practicality of the technique? What about its transparency? What about democracy and technocracy? So if we look at law, for example, there's a really interesting history of justice system taking on various forms of forensic scientific aids. And if you look back in the history of this, you see this really interesting pattern of concern that, oh, we're going to take over justice, which is meant to be a human endeavor between a person speaking to a jury of their peers, if there's a jury, or speaking to a judge and having their day in court, rather than like being measured by a machine, like a polygraph with some white coats that spit out the answer. There's a tremendous resistance to that. People think that's not justice. It's not a human kind of interaction. And yet, A lot of that stuff you see in the cases dealing with whether the polygraph test is going to be admissible or not. Another example, though, the early days of the use of DNA for identification, similar pattern. There's a real concern. What, we're doing justice by numbers now? This flipped in the space in Canada and in the US in the space of 10 years, because we went from being uncertain to actually believing strongly in DNA evidence as a very reliable identification mechanism. And no justice system could tolerate a verdict inconsistent with that data, that DNA. It had to be taken on board, and very quickly went from maybe a miscarriage of justice to use it to it's a miscarriage of justice not to use it. So at the same time, what this does tell us, though, is this sort of lurking concern about the use of non-transparent sort of technical mechanisms to do the work of justice systems. Ask yourself, though, if you're a person who's unlikely to be believed by the justice system, by the human justice system with all its foibles and biases, maybe you'd prefer the machine, right? So our romantic notions of justice being a human endeavor and a human interaction, that may be cold comfort to some people who don't tend to fare as well before the justice system. We will come back to this as well. So to me, the right question is, does the brain-based method offer a more accurate approach than what we're doing already? And is that accuracy worth the trade-offs in a given context? I think this is the correct answer. But I want to take you through, and I don't know how many of you, can I ask you to do a little poll? How many of you have heard of brain fingerprinting in the context of criminal justice? Anything? And no, okay, good. Well, I hope you'll find this interesting then. So I'm doing a project right now looking at all of the criminal justice cases in India, which took some doing, by the way, because I'm not trained in Indian law, but I had a wonderful graduate student help me with this. And we have gathered 260 cases in which this brain fingerprinting is mentioned in recorded Indian criminal cases. So what is brain fingerprinting? Well, there's a little info down here which you sort of can't see very well, but the gist of it is, as I understand it, there is a rapid positive electrical signal on EEG that the brain makes 300 milliseconds after the presentation of a significant stimulus of some kind. So the idea here is you present various known significant things, see what the brain does. You then present some unknown things and you see the null response, and then you present something to do with the crime scene. And then you can then understand, is there guilty knowledge present in the mind of the suspect or the witness? And so that's the whole idea. And it's called brain fingerprinting. They call it something a little different in India, brain electrical oscillation signature and BAYAP. And anyway, doesn't matter. It's sort of the same basic idea. It has, this is about maybe 10, 12 years ago now, that it was attempted in US courts and generally rejected as inadmissible. So there's this threshold for admissibility of scientific evidence. It has to have you need a known error rate. It has to be subjected to peer-reviewed publication, all kinds of things like that. So rejected in the US as not sufficiently established, but adopted energetically in India. So what's going on here? And I'll take you through a couple of reasons why it has been adopted in India. And it's because despite energetic critique within India, it solves a couple of major social problems. So the reason I take you through it is to illustrate that this question of how accurate does it have to be is an interesting trade-off that we made in different societies for various reasons. And even an unproven and maybe ineffective technique is being used enthusiastically because it solves a particular problem. So what kind of problem? Okay, first of all, if you go on to the Indian State Forensic Science Services, you'll see that not only do they offer brain fingerprinting, but they also offer polygraph testing and something called narcoanalysis, which in sort of the 60s was being discussed in the United States as well. But this is giving people hypnotic drugs, sodium pentothal, amytal, during interrogation. Quite something. The Supreme Court of India considered that there was a whole bunch of earlier cases in which people were resisting the involuntary application of this testing, and it came to a head in the case of Selvi in 2010, where the court had to look at questions like liberty, constitutional protection of liberty, and also self-incrimination and testimonial compulsion, and decide what to do with this. Could these be involuntarily forced on a suspect? And the answer to that was no. There can be no involuntary application of the tests, but voluntary tests are okay. Now, if there's one thing in law, is of making something voluntary is no great protection, because you can get people to actually clamor, demand the thing by making the alternative sufficiently unpleasant. So just like a consent-based regime is not going to provide much protection. Selvey goes ahead and says, we're going to provide more protection, because if the alternative is getting beaten, people might be lining up for brain fingerprinting. And so they said, okay, well, direct results cannot be admitted, even if they're voluntary, in little quotation marks, right? However, information that's subsequently discovered, and so we have this concept in legal evidence, you get some information and that sets you down a path to get other information. And so there's a question here. If you permit investigators to use that other stuff, then it allows them, it creates an incentive to do the not permitted evidence collection if they're actually allowed to use that down the line. But Selvey said, well, if you're willing to do it, then yes, we can use any evidence subsequently discovered as a result of the test. And plus we should have safeguards. But back to my point about why is there enthusiasm for this? And one of the arguments noted by the Selvey court, the Supreme Court, was it was argued that the promotion of these techniques could reduce the regrettably high incidence of third-degree methods, by which we mean beating and torture to extract confessions. So that's our first clue to what this test is doing. And if we look at the functioning of the criminal justice system, this is a survey of nearly 16,000 respondents in India in 2017 by a public policy NGO. And they asked people about their views of the police. And you can see the colors on the left, I don't know if you can quite read it, but the dark brown is people fear a lot, then it's somewhat, not much, not at all. And so questions were, how afraid are you of the police? Next line is, how afraid are you of being beaten up by the police? Quite a few people, about half, right? Third one, how afraid are you of being falsely implicated? Because that's a whole other problem, is false accusations and people who then languish in jail for years waiting in the backlog for an actual trial, and sexual harassment at the bottom. So there's a high degree of fear, which reflects basically perennial structural problems with the policing system in India, which is grossly under-resourced, which leads up to this massive backlog of cases, which then leads to pressure to solve the cases by extracting confessions one way or the other. False confessions is fine. Making false accusations to get a culprit to clear the backlog. And also corruption. Since they're not getting paid very much, they're taking bribes left, right, and center. And so all of this adds up to a system that's not functioning well. And if you have like Deus Ex Machina coming down this brain fingerprinting, it's going to be kind of useful to actually get through some of this, and especially for people falsely implicated, to try to get themselves out of the predicament. And that's what we see in the cases. So my student and I, we've been going through these 260 cases and finding all kinds of interesting things. A lot of them are accused people wanting this method of exculpating themselves. There's also concerns about corruption. This was a case where it was an investigative journalist who was killed, and he'd been investigating some people who were a bit close to politicians. The police went ahead and were getting close and accused one of these gangstery people, had a press conference, and then someone important from policing came from the center of the state. 2 days later, there's a new press conference. Oh no, the driver did it. And the poor driver got hauled in and was accused and was sitting there trying to get himself out of trouble. And the court eventually transferred the case out of the state because of concerns about corruption. And so, again, there was a desire to have this brain fingerprinting evidence because of the poor functioning of the system, in essence. And then this also is an interesting use. So you can see signs in the case of people volunteering, wanting the test as a form of signaling of their innocence. And you can see the court saying, hey, if Singh were guilty, he wouldn't have the guts to throw a challenge to the top brass of the police department to test him in this way. And so signing up for this woo-woo high-tech brain fingerprinting is interpreted as a sign of innocence. And so many sort of kind of strands behind that explain perhaps the interest in using a completely unproven technique in criminal justice. So let me move to my second topic. I'm just checking the time here. So second, what are the risks of extending the inferential chain in time? So for many socio-legal purposes, we have to make predictions about people. Well, some of them are not legal. In employment, people are always being, there's personality tests and aptitude tests and all sorts of things, trying to gauge the capacities of people in order to determine how well they'll be able to perform in a given job. So that's done all the time. And one can find various discussions of neuro prediction to test pilots and things like that. So there's a sort of a growing interest in using brain data for this purpose. In mental health care, I don't know how it works in Brazil, but we have hospitalization criteria based on dangerousness. So we're having to estimate that. Criminal justice, sentencing is a function of recidivism risk, among other things. So that is a very important part of sentencing decision. Child protection, when do you withdraw children from the family, is also a risk assessment. So all kinds of situations where we want to look at mental states and behavior and try to predict future mental states and behavior. How is it currently done? Well, a whole bunch of different ways. For lack of time, let's just focus on criminal justice system. And the way it's being done in Canada at present is there will be, in important cases, multiple psychiatric assessments looking at the person's whole medical history, but also applying what have come to be called forensic or actuarial forensic risk assessment tools. And what are these? These are basically lists of criteria: gender, age at first offense, job status, all these kinds of things, marriage or not, which have been seen across thousands of people to be predictive of recidivism or protective against recidivism. So that's how that's being done. And there's, in this day and age, and we've had talks about algorithmic bias and AI, we're kind of doing this already, although at least it's on paper and we can see what factors are being considered. And we have had recent cases in the Supreme Court of Canada complaining about G2I already. So Ewart was an Indigenous man, who said, wait a minute, your model is normed on the white North American Canadian population. What about me? Some of these risk factors may overestimate risk because I am of a different sort of cultural ethnic group. Okay, so we're doing this. What are some of the risks that might come up if we add in brain data? And what might be some of the benefits of adding in brain data? You notice that the factors I mentioned, they're very crude. They're what's your age, what's your gender, are you married? Could we improve this and have less of a kind of a stereotyped approach and do better on this G2I problem if we start to get more into capacities, functional brain capacities? And this is the argument that is sort of underlying this paper, the neuroprediction of future arrest, where there was testing of executive control in essence and linking that to risk of recidivism. Also, we have interest in using brain response to sexual stimuli to identify sexual interests as well. This is something that people are perhaps more apt to hide. There's various methods of doing this already, but this is a more high-tech, brain-based way of doing it. And so could adding brain data improve prediction? In which case, we might then have a further question, well, on what basis do we say that's a good or a bad thing? And Gabriele and colleagues talk about this and say, well, this is fantastic. Neuromarkers often provide better predictions, alone or in combination with other things than behavioral measures. And this is going to be great. We're going to be able to personalize education and clinical practices to get better outcomes for people. Sure, that's great if we do that. But what if instead we're doing it to predict recidivism or doing it to rule people out of an opportunity because we don't think they're suitable for an employment opportunity? The competition between the individual interests and the group then becomes clear. And Rice and Harris are pretty famous for having done the risk modeling, risk model construction for one of the sex offender guides, and they're really keen on this. They think functional brain imaging is the best long-term prospect for increasing the accuracy. So the question is posing this competition between individual interests and also group, the society interest. Are we going to use it in an inclusive way to identify the need for assistance and accommodation, better treatment, better support tailored to people's capacities? Or are we going to use it to identify risk, and that's the end of the discussion, put people in jail? So a further question is, what is the psychological impact of this prediction? And this is something comes under the label of self-fulfilling prophecies, the golem effect, the Pygmalion effect, the observation that people are sensitive to the expectations that others have of them, as well as the internalized expectations they have of themselves. And an example from a Canadian case, a rather old case, 2007, of a man who was being assessed, and the expert said, hey, we should do an MRI on him and sort of see if we can figure out his risk by looking at his brain. And the judge said, and actually it was the argument of the prosecution as well, wait a minute, if we're going to start looking at people's brains to assess their risk of recidivism for sentencing purposes, is there a risk here that we're going to undermine self-efficacy? We're going to change because we're neuroessentialist. We think that the brain is so important. Is it going to change self-perception in a way that will undermine the ability to move forward and to not recidivate? So are there psychological impacts of saying, it's not me, it's the brain damage? And so to me, this points to the importance of care and messaging. We need to think about whether we're looking for brain biomarkers or neuromarkers that are modifiable through neurofeedback, for example. That is there some story about brain plasticity that can be told here? Obviously, this does not work for some forms of brain damage that actually are effectively non-modifiable, but for some, could this be a palliative to these psychological effects that I'm mentioning? All right, third, we get to epistemic justice. So I introduced already the topic as this concern over the competition between the subjective perception of a mental state and what the brain data is saying. Now here I'm veering a little bit into the hypothetical or speculative, and I would like to think about, a possible future technology that can distinguish between false memory and true memory. To my knowledge, we are nowhere clear figuring that out. But if we could. So, as I said earlier, this subjective-objective conflict is always present, but I'm suggesting to you that the challenge to you psychologically is greater if I am saying your brain disagrees with what you feel than if I just say I personally, as a third party, disagree with what you feel. That you can dismiss that easily. Less easy to dismiss it, perhaps, if your brain is said to be saying something different than you expect. So you have a firm, clear memory, autobiographical memory of something happening to you. And this technology says, actually, no, that's a false memory. And we know we have false memories. This happens. So you might think, oh, okay, but it's so real. I had that happen to me. And the expert says, actually, no, that's all these markers, data, pictures, false memory. So in order to explore the justice of this, but also the psychology of it, let me take you to a historical, oops, I'm out of my slides. So here's the questions I want to ask, then I'll get to the historical example. What does epistemic justice require here? What is the impact on the person if the objective brain-based data is preferred over subjective perception? Is it going to induce self-doubt, a form of epistemic uncertainty? Are we justified in doing that to people? And then finally, can a person be harmed by preferring their subjective account? I want to turn it on its head and say, actually, we harm the person by accepting their subjective account. Are there some contexts when we should set them straight? And my answer is yes. So I have examples of each. So the memory wars, I don't know if in Brazil this was a big thing. In North America in the 90s and a little bit later, there was this phenomenon known as recovered memories of childhood sexual abuse. This usually happened in the course of counseling. People went to counselors, they're very unhappy, and the suggestion is that there was some sort of leading them to believe that they had been victims of sexual abuse, usually by family members in their childhood, and this led to families breaking down and all kinds of harm, and a major pushback, a social pushback, under the name of calling this phenomenon false memory syndrome. There were also these really quite spectacular claims by children of ritual satanic abuse, and no one could find evidence of it happening. And so it was not just in adults in counseling, but sometimes in children reporting these things. And so there was this phenomenon, the social phenomenon, which has settled down quite a bit since then. But my point is not to take you through that, but to look at the accounts of some of people who came to reject their prior memory. And so I went looking. They're called retractors or recanters, and this is highly controversial area. Let me put it that way. Some think that the retractions are untrue, that the original report was true. But anyway, let's look at what some of the retractors said. And so Gavigan, for example, says, "I still remain perplexed and disturbed as to how this all could have happened to me." Leaf and Fetkovics didn't give people's names. They were reporting on interviews they did, but reported one respondent saying, along with confusion, she felt great anxiety at not being able to decide what in the world was real. Another person said to them, "The mind is incredibly malleable." And then Marin, who had her own experience, said in her introduction to her book, said, "I've tried to verify the data that I report, but for reasons that should be obvious, I regard all, quote, facts with skepticism." So one can sort of see this kind of psychological impact of self-doubt, of generalized doubt, that came about with having that experience of the firm memory and then coming to believe it was false. So I think the impact of outsourcing epistemic authority over mental lives is at least uncertain. It may vary by person and context, the type of experience that's being challenged. But I think it's something we should consider if we're going in the direction of trying to use brain data to say something about what are the mental experiences of people when there might be a divergence between the two. There is some potential harm that might be done there. But should we do that harm? And so here I take you to, there's really interesting research on false confessions. And they seem to come in three flavors, three types. The first are the internalized false confessions, and these are typically people who are younger, who may have sort of vulnerabilities, cognitive limitations, diminished capacity, for example, people with autism spectrum disorder. There's certain people who are more vulnerable to this being induced to believe some event about their past, but it actually is experimentally relatively easy to get people to have all kinds of false memories of things they might have done. But anyway, the first kind is these internalized false confessions induced by suggestive interrogation, where people actually subjectively believe that they did the event they're confessing or the act they're confessing. Compliant false confessions, where people are just confessing to get out of a bad situation or to try to get some legal benefit. Voluntary false confessions are made to shelter some other person. You want to take the fall, the rap, to let the real culprit go free. And so suggestive interviewing techniques can induce people to have these rich false memories. So perhaps this is an instance in which we should actually be really careful about making sure we don't believe what they're saying. Now, you might say an easier thing to do is quit doing suggestive interrogations. Well, yes, that would be a good idea. But in addition, where we have concerns, should we be trying, if we could, hypothetically, tell what is a real and false memory? Could that one day help with the evaluation of confabulated confessions? And I think that's an example where it could be useful. And also, we would have an obligation, I think, to disbelieve what the person is reporting. So, what about a right to be heard? Is there an obligation to read minds? And I think in some circumstances there is. So we have all the discussion of disorders of consciousness, where there's good evidence of a failure in diagnosing between minimally conscious state or intermittent awareness and permanent vegetative state. And also people with this kind of locked-in condition who show no motor responsiveness whatsoever and are unable to communicate. And there's this remarkable research, the Monty paper in 2010, of giving people these command following tasks. Imagine playing tennis if you want to say yes. Imagine navigating through a house if you want to say no. And discovering there's some people thought to be completely unaware who are able to answer various autobiographical questions. So they're in there. Do we have an obligation to read their mind to enable them to participate in their treatment decision making, to understand what they want to do? I think yes. I think we do, clearly. And another point I'd make about people with profound motor impairment is there's tremendous vulnerability to abuse. People, if you cannot report, you're a much less threatening victim. And so there's an elevated level of abuse. There's exclusion from social life. And the development of communication, brain-computer interfaces, I think is probably going to be a really key application in addition to the motor, assisting people with motor functions. I think communication is the killer app. And so supporting my argument in favor of an obligation to read minds is the Convention on the Rights of Persons with Disabilities, where we have to promote and make accessible assistive technology. But I want to give you this. This is a fascinating chapter. I recommend it to anyone interested in this. It is a comparison of two Spanish cases of two men with major motor impairment, with locked-in state. One, Jose, had a tiny bit of motion, was able to actually work a trackball mouse, and was able to get access to computer-based technology and do a little bit of communication with the mouse. Mauricio, on the other hand, could only select single letters, which were interpreted by an aide. Both of them were ruled by the courts to be legally incapable and subject to guardianship, unable to vote, unable to dispose of their property, unable to make their own decisions. Both of them challenged in court this finding of legal incapacity. Jose won, he got his capacity back. Mauricio did not. And the comparison of the two cases is very interesting. So why was Mauricio turned down? There was concern that the use of a human intermediary raised the risk of ventriloquism. Interesting, isn't it? So I think we have to, would it be better if there's a brain-computer interface rather than a human being? Or do we think that the BCI would be less apt to produce ventriloquism than the human being? I'm not convinced. What if the BCI has we're all familiar with the error, like the autocorrect, right? All of these BCIs use some sort of autocorrect to try to predictively understand what people are trying to do with the devices. Is an autocorrect as bad as a ventriloquism risk? We have to figure all this out, but I think underlying it is an obligation to adjust our expectations to allow the communication of people in this state. Some might say, and I have read some saying, look, clearly there's going to be some decisions we're going to be very uncomfortable with leaving to people. Do you want your life support removed? We don't want to make a mistake about that. But note, these are the most consequential decisions that we're withholding from people. So the stakes are very high. And I think thinking about how we build into the system the kinds of features that allow us to be comfortable with using them is very important. And so my last ethical issue, we come back to mental privacy. And I'm at the start of thinking about this, so I confess I have a lot more reading to do. But to me, we're worried about mental privacy. So my thinking starts with, okay, well, first of all, what's privacy? And secondly, why do we care about it? So I want to know about those two things. And then I'm going to start thinking about, okay, well, the mental privacy, does that fit somehow within and in the same way in this definition and value structure? Is it different in some way? So what is privacy? I think there's many theories of this. It's been described as a protean concept. There's the kaleidoscope model where you turn a kaleidoscope and then it refracts different colors of light and it means something different. But to me, I think the foundation is the separation of the individual from others. That's what it's about. And it's about, you can see that sometimes it's about physical boundaries. It's the privacy of the body. The skin furnishes, or the personal space furnishes, the distinction between the individual and others. sort of extends to spaces, the privacy of one's house, because it's an extended personal space that is important. But that is about the physicality of privacy. There's also privacy of all sorts of intangible things about the human, about the person. This would be personal information of different types that we want to protect. And why do we want this separation from others? Why is it valuable to be separated from others? It's because without it, we can't form and maintain individual identity. And that's valuable to us. Without it, we're not shielded from surveillance. Surveillance has all kinds of constraining effects. You'll modify your behavior if you're under surveillance. You will be more at risk of exploitation and harm from others if they know a lot about you, can predict where you're going to be and what you're going to do and who you are and everything. Basically manipulate you, exploit you. Third, the other interesting value of privacy is it allows graduated degrees of closeness. You let people in to the protected sphere to varying degrees that allow you to create intimacy with other people. If everyone knew everything, you wouldn't have those sort of graduated degrees of closeness. So it has all these sort of psychological and social functions. And to me, I think mental privacy lies at the core of all of this. I think it's quite easy to see that mental privacy is going to be something very valuable to us. We haven't really had occasion to talk about it very much because we haven't had very many ways of directly getting access to minds, right? We've, as I've said, long made inferences about people's minds, but we're not greatly threatened by that because we're used to it. But I think now that we have these technologies where we can start to go in and get information about mental states, current traits, functions, we're in a little bit of a new world, I think. Stay tuned because I'm going to keep working on this and figure this out. So, does collection, dissemination of brain data threaten mental privacy? Possibly, to the extent that the inferences, as I said, correct or incorrect, are drawn about mental states. And guess what? Its secondary uses are super hard to predict of this information. So the Ross Compton case is not a brain data case. It's a guy with a pacemaker, and he was accused of burning down his house and trying to get insurance money. I don't know if you've heard of this case. This is a great case. It was in Ohio a number of years back. And so the prosecution subpoenaed, asked for his pacemaker data to basically prove that he wasn't doing what he said he was doing, and was used to prosecute him. So I can see a lot of interest in the collected brain data as we're like, okay, you're driving and you were in an accident. Well, I have data showing that you were not aware or you were distracted. Okay, very useful. So how does the law respond to this? Well, you can see different kinds of approaches, because some say, well, we should never collect any brain data. And then the concern is, are we going to impede science? What about the good uses of brain data? What about the uses of brain data where, in fact, the individual benefits from the use? So total prohibition of collection and use seems maybe okay for some contexts, but not as a blanket approach. What about access or collection with consent? Again, I'm deeply suspicious of consent as the solution to this. People will consent to anything, especially around privacy. What about we can collect it as long as we give you notice? At least you know who knows what. Also not very useful to me. I think data moves around. It's hard to control. Another approach is allow all collection, but control the uses. So an example of this approach legally is in the Genetic Information Non-Discrimination Act in the US, and we have an analog statute in Canada as well, which basically says, yeah, you can collect genetic data, it can be collected with consent, et cetera, but you cannot use it in certain contexts for health insurance and employment. So that's another approach to try to deal with this privacy issue at the legal level. Okay, so I come to the end with just a quick set of conclusions that, first of all, we already infer mental states from objective data. We're likely to get better at it, and brain data our ability to do so with brain data is going to improve. I think level of accuracy required will vary by context, and it will be a relative function of how we're already doing it. I think there's going to be some interesting, subtle social and psychological effects of coming to rely on brain data in this way. And further, justice may demand we facilitate the drawing of inferences in some contexts and protect against it in others. So bottom line, no one kind of call for absolute mental privacy is the right approach. We have to think about the sort of the subtle cases and different potential applications in order to figure out how to handle all this. Okay.
Well, a big round of applause for Jennifer Chandler. Questions? Questions, questions, questions.
Thank you, Professor, from lawyer to lawyer. This was visually beautiful because of all the pictures you have chosen. So, first of all, thanks for bringing that to us. I have at least three questions I would like to discuss about the three first points you brought. The first about accuracy. When you mention the cost of accuracy, are we talking about an utilitarian view of it? And the second, prediction, which is also related to the last one, the mental privacy. Are we considering the minority report effect? Like, we're going to start punishing people even if, like, just discriminating them before they do behave. And the other one is pretty basic. It's like, could you give me a more, how can I say that, strict concept of epistemic justice? Thank you very much.
Yeah, three great questions. Thanks, Karina. So, with the cost of accuracy, what I was thinking is, I suppose when I talk about cost, I'm thinking in a utilitarian way, but the costs I have are not just like monetary costs, for example. They are, try to get back to the right place there. Yeah, so a whole bunch of different values which could be around human dignity as well. And so when trying to think of how much we value accuracy in the assessment, if we move into this highly expensive and also technocratic mode of assessing people, it's not transparent, it's expert. And so if we value a justice system that is comprehensible, that's open to everyone to see the inner workings, then we have a cost to the justice system itself. And so that's sort of what I meant by cost, is trying to think broadly about cost, about what does it do? I mean, heck, maybe our justice system is primitive, incoherent, does a crap job, and maybe we shouldn't have it. So it may not be a cost, but I think we should ask the question: are there values in the current system that we want to maintain? Yeah, there may be, we may be buying accuracy at the cost of these other values. And then your second question with prediction, I think you're right on in terms of the concerns. I emphasized more the self-fulfilling prophecy on how it might influence the individual's psychology and behavior. But I think it's going to influence how other people say the predictions being made about me. It's going to influence how other people treat me as well, in a potentially minority reportish kind of way. So in Canada, for example, we have a category of people, we call them dangerous offenders, which is defined in the penal code, for people who've committed very serious crimes, and the concern is that they pose an ongoing risk. And the sentence is indeterminate detention. It's not like a set number of years tied to whatever you did. It's just like, you just go to jail until we think you're safe. So that is not, the courts have said that's okay, that's constitutional, that is a valid sentence. It's not pre-punishment for future acts. It's rather calibrated punishment for a past act, because incapacitation and public safety is a valid penal goal. And but that gets us into sort of minority report. It's not so much we know you're going to do X in the future, we think you are, and so we're just going to quarantine you in advance. And we are already doing that, although to a smallish number of people. Will we do more of that with the brain data? Or will we do less of it because we will have a finer judgment of actual real risk and also how to address that risk? And then your last question, a concept of epistemic justice. So Miranda Fricker, I believe, has a book on epistemic justice, but her interest is more in the status of people as knowledge holders and how it can be unfair to devalue the epistemic authority of some people on the basis of race, sex, etc. These are the categories she looks at. So that's a pretty well-established kind of discussion of epistemic justice, but my approach is quite different. I'm thinking not so much justice of disbelieving people on the basis of race or sex or whatever. I'm talking about what happens when we disbelieve them on the basis of their brain data, which could apply to any of us, but it's a different flavor of this justice question, I think. Do we do wrong to the person as a knower of themselves when we say, actually, this data over here says something else? Can your brain data be unjust to you? Or is it we are being unjust to you by relying on your brain data? So those are the kinds of things I was thinking of there.
Questions? I have a question myself. If no one has a question, I have a bunch of questions, but try to give room to you. My first question, Jennifer, is about the usage of MRI as a tool for lie detection. In the US is being used. Stanford is an important university. They support that. They will favor. How do you see that? What kind of usage we can have for lie detection in MRI that could be used just for exculpation or attenuation, or can be used also as positive proofs? What is your take in this subject?
Sorry, just to clarify, you're talking about the polygraph lie detection?
No, MRI lie detection.
Oh, MRI.
Yeah.
Oh, okay. It's not admissible in the United States, but you're asking, should we?
No, I'm just saying that for example, Stanford University defended it, and it is not yet legal or accepted, but there are many universities that defend the idea that it's much better than a polygraph, more precise. That's why I was asking if you think it could be used just for example, exculpation or attenuation, or if you think that will be acceptable to use it as for positive proofs.
So I guess I come back to my question about how are we currently doing this, and is the current approach fair? And so if we know already that in some kinds of contexts we're very poor at judging deceptiveness, and if we know we're systematically more likely to judge certain groups of people than others as deceptive, I think we are on notice that there's an unfairness in the system. And so we should be looking for ways to address that. So, and if it turns out that fMRI can do that, we should consider it. At the same time, and I didn't copy the quote for you, but it was in one of the Indian cases discussing, should we use this brain fingerprinting? And the prosecution said, oh my gosh, if we let it in, it's gonna be complete chaos. Everybody's gonna demand it. We're going to extend the prosecution or the cases. We've already groaning under the weight of the backlog, and now everybody's gonna have a right to demand it, to defend themselves, and it's really super expensive. And so those are the kinds of costs I pointed to, the cost of doing fairness, I think, with this technology. And so I personally think that if it is effective, I think there's a good case for it, but it's going to come at a cost.
And now comes a trickier question. I mean, the MRI No Lie company, they were a private company, and people used their services to test particular subjects. As for example, someone think they were cheated, and they asked the spouse to enter in the MRI. They received questions, and MRI No Lie is used as a fine-grained detection tool for honesty, for the veracity of testimony. Do you think the state can allow private companies to, invade? It's not invasive in the sense of a surgery, but it's the invasive technique of a private space of a brain. Do you think this is fair? A private company working as a kind of a judge of veracity of declaration of people. Do you think that could? It is sound that this is allowed and is being used, and because it is part of the private initiative, it's not the government, and it's pretty invasive, isn't it? So I would like to have your take on this subject.
That's an interesting one. There's private companies doing way worse stuff right now than, and we let that all go by. I don't know. I think I wouldn't say something simple like we have only to fear the government and not private companies. I think there are tremendous risks with private companies as well, but in this context, I'm not too worried about a private company trying to sell this to people. People can use it if they want. The pressure that we can put on each other in private relationships to go and sort of subject oneself to it, I don't think it's the kind of pressure that I would regard as dangerous, I think, as criminal justice system. Yeah.
Questions. So if there's no, Peter.
So I've dealt with a lot of MRI and EEG data, and the information only really comes out after averaging lots and lots of trials. So brain data is really noisy. So maybe eventually we'll get to the point where we can read it out to the point where I can know that you're thinking something very specific, but I don't think we're very close. And also what we measure is really a shadow of neural activity. For example, the bold signal is a shadow of neural activity that follows seconds later, and ERPs, event-related potentials, are typically local field potentials, involving the averaging of lots of neurons. So I guess I'm not as worried about the power of the science. I don't think it's that dangerous yet, but maybe it'll get there. Mm-hmm. But I was wondering if you could talk about the other issue, the issue of possibly taking a causal approach, not just looking at correlations of thoughts, but actually manipulating thoughts with implants and, now they have opto and they can put light and activate any neurons they want. And that's what we do. I mean, have you seen this stuff with rats? Mm-hmm. They can make a rat turn left or right. Mm-hmm. Flash this light, turns left, flash, and I do worry if we become the puppets of any external power, government or private. That's, to me, a lot scarier. Mm-hmm. So, I don't know, just some thoughts.
Yeah, definitely. I just finished a paper on, it's kind of a boring legal paper, to be honest, but it's looking at the legal issues that arise for telemedical management of deep brain stimulation, because during COVID, people with deep brain stimulators, it was difficult to travel to like the central hospital to get stimulation adjusted and so forth. So these devices are being networked basically so that you can tune them up over telecoms. What could go wrong? So like having something in your head that the stimulation could be modified, hacked, an error made in a way that would then, in the case of DBS or Parkinson, affect your ability to move suddenly, that's kind of worrisome. And I agree with you. I think some of these implants actually have interesting sort of psychological side effects as well, with a minority getting impulse control disorders and things like that. So there's some really interesting legal questions to be sorted out in terms of responsibility as well, when you have this kind of hybrid biological hardware software fusion, which is collectively producing the cognitive state of the individual. How do we sort out self-ownership and responsibility, among other things?
Any other questions? Any other questions, please? So now we officially finished the closing talk. A big round of applause for Jennifer Chandler. Well, everything has come to an end. So well, we have a bunch of people to, a bunch of acknowledgements. First of all, a big round of applause for the safety guards of the National Archives that did a great job, help us a lot. A big round of applause for the director of the National Archives, Ana Flávia Magalhães Pinto, that allow us to be here. A big round of applause for Gecilda Esteves, the adjunct director of the National Archives, that was the person that was dealt with all the bureaucracy you have to go through. A big round of applause for Gecilda. A big round of applause for our wonderful cinematographers, Renan Veiga e Matheus Dorinha. A big round of applause also for the sound technicians of the National Archives, Dinho, Betinho, and Ribamar, that help us a lot. And now I have a strange announcement, because we decided to give prizes to the students. Why I didn't say that in advance? Because I thought that if we said we're going to give prizes, people will be stressed, or maybe showboating, or I don't know. So I prefer to keep this in privacy and announce now the two communications, the two talks. There will be, they wouldn't have like a physical prize. They will have a certificate, but they be laureates. We call the prize in English the brainy owl, because our symbol is this mixture. The owl represents the philosophy, the brain, the neuroscience, and coruja cerebral in Portuguese. So for the best student presentation in English, unify intercepted theoretical models and predictive processing in chronic pain experience, a comprehensive review. Yuri Cordeiro Estremeta e Alisson Brandemarte. A big round of applause. It was really a great presentation. One of them is an undergrad and the other is a master's student. It's impressive how such young researchers could put together such a beautiful, both theoretical and empirical work review. And for best work in Portuguese, Provas dependentes da memória e decisão sobre fatos no processo penal, Michael Guedes da Rocha. I want to clarify that none of the students of the organizing committee are allowed to compete on this thing, because it's a question of objective transparency and fairness. I mean, we will be biased to consider those there from the team in the equation. I want to thank all the keynote speakers. I want to thank all the invited speakers, but I want a big round of applause for Thiago and Bruno for the very hard work they did. Big round of applause for Thiago and Bruno. And what else? I have something interesting here. It's an opportunity. 8th of this month, it will be published an edit. I have 24 months of a scholarship for a PhD. Whoever is interested in working with me can apply for that. This is also something positive. And, well, thanks for your presence. Thanks for your attention. And let's be in contact. Everyone that is here, we have the emails. If you want certificates, you send an email for the organizing committee. Thanks a lot for everything.